What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And today we're going to be jumping back into all the Karen Reed pretrial motions, hearings, arguments, expert testimony, discussions about the feds and their involvement in this case with the experts. And I'm going to bring in the person you guys always love to hear about when we talk about the feds, and that's my dad. He's going to be joining me today for the podcast to discuss, will this trial start on time? What does he think about the experts? And to talk a little bit more about how the federal government gets involved in cases like this and what this nefarious relationship Hank Brennan is trying to describe actually looks like when you're seeing it from the Fed side and from a criminal defense attorney's perspective. So without further ado, let's get into it. What's up, Dad? Welcome in
Hello.
here.
Morning.
I have some, yeah, they'll be listening to it in the morning, so that works too. It is
Oh,
still
okay.
morning here.
All right.
So I have some questions I wanted to just kind of pick your brain about and discuss as a lawyer. I think I kind of know where you're going to fall on most of these, but just interested to hear your perspective on a case like this that has already been tried once, right? So a lot of the information's already out there. The judge has already made a decision on a lot of the things that they're still fighting about now. Some experts that were allowed to testify as experts in the first case, there were motions to exclude them. Some evidence that was allowed in the first case, there's motion in limine to not allow it or to pare it down. Or now we know how it has affected potential jurors in this case because we know how it affected jurors in the first case. So much going on, but a new special prosecutor, a new member of the defense team, a lot of new experts, and a lot of new evidence as well. Additionally, some things that were still open in the first case, like Michael Proctor's internal affairs investigation, that was still open. Now it's closed. He's been terminated. They have findings. The federal investigation that was reportedly open, potentially into the investigation of the investigation, and now reportedly closed. Can we confirm that? It's very difficult. But when you're talking about all the things going on, and not to mention the potential that the jury has already made a decision, and now there's an appellate court ruling denying all the defense's motions or all their appeals, except for the last one now that's still open in federal court. And the defense wants to allow them the opportunity to make their decision because if they throw out count one or count three or both, it will change everything if they start this first trial. So it seems like the appellate counsel for the Commonwealth agrees. And so, what do you think first about a stipulation for a very short continuance from April 1st to April 25th that the judge immediately denied?
Well, two things. One is I think the stipulation was certainly reasonable. I'm surprised the Commonwealth went along with it because normally they wouldn't go along with anything that the defense wants. But they went ahead and went along with it. So they must have had good reason. They probably logicked it out and figured that's going to save time, money, and expense to go ahead and just wait a couple of weeks. But looking at the judge's ruling, I think she did a great job. I think she fashioned a really good ruling. First of all, she doesn't want to continue the trial because if you've been involved in this kind of work, you realize it's not easy to bring all these jurors in and send the subpoenas out for jurors and bring the jury pool in and all the questioning. Up there, apparently it takes 10 weeks to bring a new jury in. So she didn't want to delay it 10 weeks. And so she fashioned a way to do it because we know it's going to take a while to pick a jury in a case like this. She knows it. So let's pick the jury. Jeopardy doesn't attach when you just pick a jury. Jeopardy attaches when you start to do evidence. So pick the jury, see where we are date-wise, and maybe we're just talking about a couple days that she has to do a delay. So she did a really good job of fashioning a way of, go ahead, I'll kind of give you your continuance, but we're not going to delay the trial.
Yeah, the judge in the YNW Melly retrial kind of did the same thing in order to get it in under speedy. They started kind of picking a jury, kind of dealing with the issues. So judges do stuff like this. I agree. I thought it was a good ruling as long as it's a good ruling, as long as if they only take 1 week to pick the jury, I hope she still waits until April 25th to actually swear them in and start the trial, which this ruling leaves that open. So if they have a jury picked by April 8th and she starts the trial April 8th, I'm going to disagree that this was a good ruling. If she allows them till April 25th or some kind of delay, if it only takes them a week to pick the jury, then I like how she set this up because we're not going to delay the trial. We're going to have a jury ready to start April 25th, swear them in, and let's get going. No reason to delay the case any further.
Right. So I think she did a really good job.
The next question I had is there's all this expert discovery challenges, questioning going on, voir dire, Daubert Lanigan challenges. What do you think about that? What do you think from a lawyer's perspective when it seems like both sides are trying to challenge every expert, even experts that were allowed in the first trial? And what do you think of some of the judges' rulings, making all the defense experts come in for sometimes multiple day Daubert hearings and not making any of the Commonwealth experts come in, but instead just allowing them, even some experts that were not in trial one? Yet, at least three off the top of my head that I can remember that testified at trial one for the defense all had to come back and do a voir dire, sometimes again, multiple days that the defense had to pay for. And then you have a Commonwealth expert that the defense tried to challenge that she didn't even give a Daubert hearing. Instead, she just allowed him with a very short rubber stamp, basically.
Well, I think that it's appropriate for her to take these individually and not do a general order saying everybody needs to voir dire. So she looked at them individually to see what they had to do and what kind of experts they were. The challenge on the ARCCA experts, the voir dire that she's looking at, doesn't go to their expertise, at least the way that I viewed her ruling. It goes to the Rule 14 discovery issues. So they're coming in. It's whether or not there's going to be some limitation on their testimony based on the discovery issues, which right now I predict there will not be. I think that she's indicated that she's going to give the Commonwealth, I love saying Commonwealth, the Commonwealth broad discretion in their cross examination. She's said that. So she is going to let them go crazy on these experts as far as cross. But we still have the outstanding issue of how far can we go with reference to the fact that they were hired by the feds as part of a federal investigation. That is still an open question. So I still think that she's doing the right thing with regards to discovery, since discovery is incomplete. Although they didn't always say that in their arguments, they made it sound like they got no discovery, but we know they did get some. So whether or not the additional Rule 14 discovery requires some limitation on the experts, I don't know. But she did the right thing there. I think she's doing the right thing on the experts. I do think it's a waste of time to try to totally exclude these experts because they testified in the first trial. She ruled that their testimony was relevant. She ruled that they were experts and that they can give opinions. So they're going to come in. So now the Commonwealth is trying just to pick away a little bit and to get additional discovery. The more times you can cross-examine a witness, the more inconsistent statements you're able to develop, so that when they testify at trial, you cross-examine them based on, but in the first trial you said this. They probably won't use that language, but in the first you gave a statement here that said this. Then we've got the voir dire. But in the voir dire you said this. So which one is it? Which one of these three opinions is accurate, or which one of these three statements? So it gives them a broader range of statements in which to cross-examine the witnesses, which is a real benefit to the Commonwealth.
So again, and I'm with you on the ARC experts, but to go back and maybe you didn't watch these because I know you watched just kind of the last couple hearings, but with specific reference to the dog bite experts, when you're the defense and you have a dog bite expert that was a cop who investigated dog bite cases, a medical examiner, an ER doctor who treated dog bite cases and motor vehicle accidents, who's been a doctor for like a million years, and she makes you have a 2-day voir dire process on them. She was already allowed to testify in the first trial, still allowed that. And then in her order granting or denying the state's motion to exclude that witness, she's like, oh, but there are problems. It was a close call. And then the Commonwealth puts up an expert that's not a doctor, not a vet, not an odontologist, nobody that really has the normal education that you would expect to be able to testify about this. And which is fine. He's got some background in it. He's got some expertise as a dog behavioralist, testifying about, dogs and how they act and when they're aggressive. And then she just rubber stamps that one. So you think she handled that completely appropriately, no issues with making the defense come out and have like, if you were the defense attorney, how would you feel making you do all this extra work and then the Commonwealth just a rubber stamp, even for a seemingly much less qualified expert?
Well, of course I wouldn't like it, but if they satisfied the Daubert requirements on that dog bite person, that's really the issue. And if they satisfied it, and they satisfied her, she has broad discretion in this. If they satisfied it to her, what's the standard? Try what the standard is for her for whether or not she approves it for Daubert. her judicial, whatever her discretion is. But for her discretion, she approves it. Abuse of discretion. That's the word I'm looking for. So if she approves it and the appellate court's going to bend her way because they're going to have a
Sure, I'm not
presumption,
saying she
for
made the wrong
instance.
decision. I'm not saying she made
Oh,
the wrong
okay.
decision to allow both experts. What I'm saying is the process that she used for the one that seems way more qualified to make her go through a 2-day Daubert hearing and of voir dire and not make the other one seems inconsistent to me if you're the judge and this is what you're going to do. And to say the one that really has no methodology or qualifications to rubber stamp him, if you're a judge that allows all experts and you're pretty broad, that doesn't bother me, right? And a lot of judges are like that. And most experts do get allowed. I tell everybody, don't get your hopes up when an expert gets challenged. It's very rare that an expert gets struck. It's the process in which she handled apples to apples being so completely different to me that is a really bad look for a judge. And if we were the defense attorney, I think that's something that we would take very serious issue with, that you are not being even handed with how you're handling the Commonwealth's witnesses versus how you're handling the defense witnesses. And again, this is not a tech expert versus a dog bite expert. These are two dog bite experts handled completely differently. The orders, one was a 3-page order where she went into specifics of what the Commonwealth can and should cross-examine the defense's dog bite expert. And when it's the Commonwealth's dog bite expert, she's like, he satisfies Daubert landing it. And that was it.
I don't know what was in her head. I don't
Yeah.
know, what she saw in one versus the other. It happens all the time,
Yeah.
and where a judge will say, "Oh, this expert is great, but this one I want to hear more." It happens all the time. I don't know what's in her head, but no appellate court's going to reverse her on it as long as
No, I
there's
agree.
some basis, and there looks like there is at least some basis for allowing the testimony.
Yeah. I mean, here's the point. People could say, oh, this person has no methodology. It's not a good expert, bad expert, junk science, whatever. But to me, none of that matters as much as her process being very different
Okay.
within the same week with the same exact type of expert, just two different sides. That was the biggest issue to me. And I know for a fact, if it happened to you in a case, how you would feel about it, and
Oh,
you would
sure.
just light the house on fire because it just seems like the Commonwealth can come up with any expert they want and get it rubber stamped, which is fine. That's how I feel in a lot of cases. If I bring an expert, they have the right education expertise, I know it's going to get rubber stamped. But the defense, making them pay money, making them fly experts out, making them have experts even that testified in the first trial come into another voir dire, to me, that shows a problematic system that it's not even-handed with the judge in this case, at least with how she's dealing with the experts.
I would look at the way she's dealing with the ARCA experts different than the dog bite.
I agree. I agree. I agree.
I do.
And that's what
I
I'm
think
saying.
she's dealing. They're different.
I agree. Um, and it'll be interesting to see what happens. But this kind of pushes us into the discussion about the feds and their involvement in the case and how much involvement they have, what that involvement actually is. And in the most recent hearing, Hank Brennan tries to describe this relationship, quote unquote, between the defense and the feds as if they're colluding together inappropriately and they weren't invited to the party as the Commonwealth. And if the defense really wants to go there and say that the FBI hired these experts, then we've got to go the full distance. So let's listen to some of Hank Brennan's comments in the motion, and then we'll get your thoughts on it.
Retained by the federal government, including the ARCCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case.
So let's just start with that. The defense made an inquiry to the federal government to look into this investigation, and they had an opportunity to advocate for their position. How unusual, let's take it piece by piece. For a defense to ask the feds to look into a state investigation, how unusual is that?
That happens. That happens as a tactic, to be able to say, there's an open federal investigation. Because frankly, it doesn't take much to open a federal investigation. As we hear, and I'll wait till you finish the clip because there's some background I want to give
Yeah.
about the way the country works versus the
Yeah.
way it works in Massachusetts.
Green Chef is the #1 meal kit for clean eating, delivering pre-portioned and prepped quality whole foods with limited processed ingredients. Green Chef sends organic, fresh produce, responsibly sourced proteins, and chef-designed recipes in every box for satisfying, nourishing, and convenient meals that make it easy to stick to a clean eating routine. And these days, clean eating is the most important part of what I think about when I eat every day and preparing meals for my kids and my family. And Green Fresh takes so much of the prep and the time and the misery and the stress and the shopping out of it. They make it so easy to eat clean. And that's really why I love using Green Chef. They even help you stay on track on your busiest days with salads ready in 5 minutes or less, ready to blend smoothies, and grab and go protein packed breakfasts. Those are some of the hardest things for me is snacks and breakfast. And Green Chef is when it comes to that. So thrive all year with clean, easy meals from Green Chef. Go to greenchef.com/LYK free and use code LYKFREE to get started with free salads for 2 months plus 50% off your first box. Yeah, and I want to ask some specific questions so we can piece by piece it and not have it get lost in the explanation. But
Right.
okay, so that was section number 1. Question number 2 is how unusual is it for the federal government to take that inquiry, hire experts, spend money, do an actual investigation, get all this stuff together just because the defense attorney asked you to look into an investigation?
That is unusual. And like I said, at some point when you want me to, I will
Yes,
give a broader.
we'll
You want
get
me to do
there.
it now, or you want to wait?
No, no, wait, because there's more coming. And then the
Okay.
last part, and this is going to be even more broad. So, in this situation, or if our client in a federal criminal case is being investigated, how unusual is it for the feds to allow the criminal defense team to provide them with information or advocate for their position?
That's done all the time. The feds will take anything anybody wants to
Right.
give them. So you
Exactly.
want to give me your file? I'll take. Now later on, we'll see where the file was subpoenaed. I don't know if you're going to
Correct.
show
Yes, we'll
that.
get there. Yes. Yes,
Okay.
I have that. All right, let's listen a little bit more.
including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is.
If you had to guess, who gave the FBI experts that were hired and paid by the FBI the materials that they were going to review?
Well, the defense, and they gave it
You think
through
the
the.
defense? You think the defense gave the ARCA experts the materials they were going to review?
I think the defense,
Oh,
yes, because it was the
no
whole. You
way.
don't think so? You think the state did? The
No
Commonwealth?
way. I think the feds decided what they were going to give their own witnesses. I think the feds
Oh,
took
I'm
all the
sorry.
information in.
But they got this. They didn't get the stuff in a vacuum. They had to get it from somewhere, and I
Sure.
think
Oh,
they got it from the discovery in the case.
but that's not the question. The question is not how did the feds get their information? Because I think the feds got their information from both sides. I think they got information from the Commonwealth. I think they got information from the defense. I think they got information on their own, sending out investigators public records that they were able to get, all sorts of different situations that they were able to get a hold of. But I think the feds were the one that determined what they were going to give the ARCA witnesses. There's no way
Oh,
they would let the defense attorneys determine what ARCA was going to
right.
review.
And that narrow question, who gave what to the ARCA? It was the feds that gave it to them.
Oh
Absolutely.
yeah.
Yes. I
Yeah, yeah, yeah.
understand that.
Had to be. Had to
Yeah.
be.
Is a undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so to date,
Okay. I'm sorry I keep stopping it because every line is something to really pick apart here because he's trying to make it seem like something. He said an undefined relationship between the defense and the feds, and it's still an ongoing relationship unbeknownst to them. How would you define the relationship between the feds and the defense?
Well, first off, I laughed when I heard this. When I listened to this the first time, this was funny because he's making it sound like the U.S. Attorney's Office, the federal prosecutors, put their arm around the defense and said, "Hey, we're buddies. You and I are in this together. We're good buds. We're just we're friendly." And the state prosecutors, oh, they're our enemies. That doesn't happen. And the U.S. Attorney's Office independently decided who they're going to listen to and what they were going to see. And they were not influenced by being buddy-buddy with any defense lawyer. That doesn't happen.
No, what happens is the defense lawyers beg to get a meeting, and the prosecutors are like, sure, come sit down right here at our office, and we'll tell you whether or not we're going to use any of this stuff. And we're going to pick and choose what you tell
Yeah,
us that we want to use. And then we'll send you on your way, and we'll let you know whenever we want,
right.
whatever information we want to let you know. That's how
And
it works.
we'll tell you nothing. We'll sit
Exactly.
down at this meeting and we'll tell you nothing, but you can tell us anything you want.
Actually, it's worse than we'll tell you nothing. You call our experts because you think they're going to be good for you and you want to hire them. We're going to tell you you can't hire them. We're going to tell you they can't talk to you, actually, because that's what happened here. It's not some nefarious collusion between the United States government and this defense team. Like, that's the thing that's so mind boggling about how he's trying to explain this to Judge Canoni. And it's like, this looks bad for you. It looks, because usually the state and federal prosecutors can work together if they have some kind of parallel
Well,
investigation into the bad guy.
and that's why, again, this is a good time to just say it, but there are 94 federal districts in the country.
Mhm. Go ahead. You can give
In
the explanation now. We're going to listen to more of this, but you can
yeah,
give the
those
explanation now.
those 94 federal districts all have state prosecutors in there, as well as the U.S. attorney, the federal prosecutor. It is normal for them to all have lunch together, for all of them to get together because they share investigations. The state prosecutors sometimes will give cases to the feds because they think the feds can handle it better. The feds will give cases to the state because they think the state can handle it better. They're usually like this all over the country. In Tampa, where our office, we would regularly meet with the state attorney's office. We had no conflicts with the state attorney's office. Something's going on in the federal district in Massachusetts for them to have such distrust, such a conflict. The investigation might have been closed, but what he's saying exhibits something that is so rare in the country, where there is a conflict between the U.S. Attorney's Office and local state prosecutors. That just doesn't work for the benefit of the people of that district. That works to their detriment. And that's why you don't see it happening very much. He's admitting a real problem in Massachusetts.
And so many times, just like you, people go from being a state prosecutor in the middle district to being a federal prosecutor in the middle
Right.
district, right? So
Right.
that a lot of it's training ground. Sometimes you step your way up to being a federal prosecutor. That's not unusual. So obviously, when you did that, your former boss was still the state attorney in Pinellas and Pasco County. So it's like those relationships are still there. You learned how to be a prosecutor. And then the guy that you worked with as a prosecutor became the state attorney for a million years. And it's like that's how that stuff usually happens. That's how that stuff usually works. So the relationship is usually good between state and federal prosecutors. And no criminal defense attorney is going to stand up there and be like, well, judge, we're not sure about the relationship between this state prosecutor and this federal prosecutor. It seems like they might be working together. It's like, yeah, duh. They're prosecutors. That's what they do. That's what makes this case so weird, is that this state prosecution office is, it seems, nervous or looking at it like in a negative way that the federal prosecutors would even talk to this defense team. That's what's so unusual about it to me.
And it's humorous. I mean, it really is funny for me at least, it is really funny to hear a state prosecutor say, "We don't know what kind of relationship that these people have with the U.S. Attorney's Office." I mean, I've never heard a prosecutor say something like that. That just was really, really off the wall.
Yeah. And there's more. So we'll keep listening.
As we sit here, we really don't know. What we know is ARCCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective. Just to give one point.
Do you agree with that? Like, is that misleading to say the federal government hired them to do these experiments?
It's not misleading. I mean,
That's
the
what he
federal
said. He said
government
it's misleading.
Well,
I
I
don't
mean, the
understand how
federal
it's
government did
misleading.
hire. It's not misleading. Well, again, are we talking about facts? Are we talking about opinion? That's a fact.
Yeah.
So, I mean, there's
Well,
no doubt that's a fact.
you mean it's a fact that the federal government hired them,
Yes,
right? And it's his opinion that they're not neutral.
right. That's an
Right.
opinion versus the
Right.
fact.
Right.
Point that emphasizes the concern. The ARCCA witnesses were never given information about DNA. And yet, when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was.
Bringing that up to me is like, yeah, that's a great point on cross. That's exactly what you should do to cross-examine experts. You would do that with any expert. Why does that make them not hired by the feds? I don't understand how that means the head feds must not have hired them.
Well, not just that, but the state had every opportunity to give that information to the feds. You know, they act like the feds wouldn't have taken it. they, they would have taken anything the Commonwealth wanted to give them at any time, at any place. I mean, they probably all I have to do is walk across the street. I mean, it's ridiculous for him to say that he was cut out of the process when he could have inserted himself into it and he didn't want to.
Well, and that was the accusation he made for the defense, that they went to the feds. They brought
Right.
this to the feds. They tried to push this. And then the language changes when he talks about the Commonwealth. We weren't invited to the party. Well,
They don't
nobody
have
was
to be
invited to the
invited.
party.
They
And
don't
no,
have to
the
be
defense
invited.
wasn't invited either.
Right.
It's wild.
There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if
So they testified to some of that during the first trial, for sure. But do you think there will be lines they cannot cross and information they cannot share about their relationship with the feds, what they told them, what their contract was, things like that?
Yeah, there are things they can't share, but the point really being of those particular issues he's talking about here, 90% of that is legitimate cross-examination that he can cross-examine them on. They don't need to do a proffer outside the presence of the jury. What he wants to do is he wants to find out what the answers are, so he's not embarrassed if he asks those questions in front of the jury. So he's trying to get it both ways. He's trying to hide from the jury answers that hurt him, so he doesn't ask those questions in front of the jury. But he should. That's cross-examination. If he wants that information, it's legitimate. Ask it in front of the jury.
even if the ARCCA witnesses come in to be questioned as they should well before trial, in my opinion. We do not have the opportunity to question the United States Attorney's Office. We resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case and all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is.
So he says the court should do what they did last trial. But what do you think about that last little section that he said, where basically if we tell them the feds hired these witnesses, then we'll have no choice but to go into the inculpatory evidence, which they're already going to do on cross, and to say that the investigation is closed, which implies something very bad for the defense.
Well, that's a two-part question. Number one, the first part is, can they get in and cross-examine him about these inculpatory statements or evidence? Absolutely. Good cross-examination. Totally legitimate cross-examination. Can they get into the fact that the feds closed the investigation? I do not think that that's legitimate for that to come before the jury. Because a couple things. One is closing the investigation, which is not an indication of innocence. It's not an indication they didn't find any wrongdoing. It also, we have a statute of limitations that hasn't run. So they could always open the investigation again and come after them. So it's not evidentiary that an investigation is, at this time, is closed. But again, it is certainly legitimate for him to go into all the stuff that he thinks proves his case when he's cross-examining the ARCCA witnesses.
Yeah, and to me, when you're talking about how they're going to handle the investigation being open or closed, you don't need to. Here's the relevance, right? Because we have to talk about what's relevant. Is that investigation being open or closed relevant to this trial? In my opinion, no. What is relevant, because the Commonwealth wants to ask it and they should be able to ask it, is the bias or lack of bias of an expert witness. So if they're going to say, defense, you talked to these guys, you paid these guys, these are your guys, they're biased for you. Okay. They didn't look at this information that's inculpatory. They clearly wanted to help you guys out. Well, the relevant response is the feds hired them to do this experiment, to come up with this report, to come up with their opinions. That is the end of the relevant information, in my opinion, to this trial. There's no reason. He says it's going to have to be a trial within a trial, which we'll get to that clip, but there's no reason for it to be a trial within a trial for what's relevant to this case. And then, even if they did want to get into the investigation, the government's limitations, what we know and what we don't know, how is that bad for the defense?
No, I mean, it's a situation where I think he really is trying to make it look as bad as possible to keep the witnesses out. That's all it is. All it is trying to get this judge, because judges inherently don't want their trials to become circuses. This trial is already bad enough. So this judge is not going to want this to become, just to explode into the federal investigation. So he's trying to tell the judge, hey, judge, look, keep these guys out so we don't explode this into talking about the federal investigation.
Not just keep these guys out, but he means keep out that the feds hired them. That he
Right.
said he said he doesn't care if these witnesses testify.
Right.
He
Right.
wants to
Keep
make
them out.
them, yeah, he wants to make them seem like defense witnesses that they paid, they hired, biased towards the defense, like every other expert. But they're not, and that's what makes this so different. And to me, it does make a difference. But I know the feds hired them. The jury thought, if you believe some of the jurors that have come out and spoke, that Karen Reed's insurance company hired them, or a Karen Reed supporter hired them. So then that does lump them in with every other expert when you're balancing things. So from my perspective, it does feel like this is something that could be relevant. Now, it's incredibly prejudicial to the Commonwealth to say that the feds hired them. So in my opinion, if I was the Commonwealth, I may propose something. They don't have to probably, but I would propose something like, we won't bring up what they paid them, judge. Let's just say independent third party hired them like the first trial and be done. But he wants to also bring in the fact that they've paid them 25, however many thousands of dollars. And that to me is what makes now the feds hiring them more relevant. And it might not be outweighed by the prejudicial effect. And that's the difference. To me, he's opening the door to the fact that the FBI actually hired them by trying to make it seem like these are defense witnesses that they're paying.
You may know differently, but as from what I have seen, we don't know how much the federal government paid these witnesses.
I've seen reports, but I don't know the answer.
Right. So we don't know if the $26,000 is a drop in the bucket versus, maybe they paid them $150,000 and that 26 is just a drop in the bucket, because we know the 26 really, from what I've seen, only paid for their trial testimony and preparation for trial.
And their voir dire testimony and their travel, planes, hotels, etc.
Costs. Right. So that's all the 26 covers. So the vast majority, and what actually paid for their report and what actually paid for the experiment, was paid by the federal government and not by the defense. That's pretty relevant when you really think about it, if he's going to go after them.
I agree. And that's his.
So it's an unfair inference that he's trying to draw with reference to this $26,000, because to most people on that jury, $26,000 is going to sound like a lot of money. And
Correct.
it's going to make it look like, oh, these guys were bought and paid for. But what it really would, again, be the truth, probably, is that they got paid $200,000, and this 26,000 is a drop in the bucket, and that their experiments and their opinions and all that stuff was paid for by an independent third party who had no bias or interest in the results of the trial. That's an important point. And again, Brennan knows what he's doing. He knows what he's trying to do because he knows how that's going to benefit the defense.
Well, it's smart because it's a big deal. Like
Right.
if the fact gets out that the feds, and all the reports I saw the feds paid them way more. I think it was like 22 or 23,000, but whatever. I think the 26 number is actually less than that, but whatever. I think the feds paid them way more than that. And that's the interesting perspective here, is that Brennan, in my opinion, is opening the door to making the hiring by the feds more relevant, because if he doesn't bring that up, the prejudicial effects probably does outweigh the probative value of saying the feds hired them. If he doesn't bring up that the defense paid them and tries to make it look like defense experts, if we just leave it at independent third party, I can understand why the judge would come down on that. But to get rid of that and say the defense paid them all this money, to me now is creating a false narrative. And we don't want to lie to juries. We don't want to misrepresent things to juries. So if he wants to tell them the truth, that the defense paid them over $20,000, they should also hear the truth that the feds hired them to do X, Y, and Z, and here's how much the feds paid them.
Right.
We're in agreement there.
And the 20,000, if he gets into that 20,000, the defense should be able to say, okay, what was that for? What did we pay you for?
Yeah.
And they're going to say, so we did not pay you for your opinions. We did not pay you to do the experiment. We did not pay you to review the evidence. Somebody else paid you for that. That
Yeah.
should all come in.
I think it will. I think it will. All right. Let's keep listening.
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Iannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Iannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Iannetti on March 29, 2023 describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth.
So he's saying, like, we should tell the jury that the feds were working with the defense? Like, why is that scary for the defense? Why is that bad for the defense to say, yeah, the feds put their arm around the defense? How bad is that?
Well, it is because it hurts the ARCCA witnesses.
I would take that.
Yeah, but it does hurt the ARCCA witnesses. But again, it's just it's a ridiculous argument, logically a ridiculous argument. But I give him credit for one thing. He quickly was able to counter well, if we're looking for the truth, let's tell them all the truth. That was a real politician's answer for something that, I mean, it's a meaningless statement, but it sounds good. I mean, it's a great sound bite. If you want to know the truth, let's all, you want to know the truth, you can't handle the truth. It's that kind of statement. If you want to know the truth, let's tell them all the truth. I stand for truth and justice. I'm the Commonwealth.
Yeah.
Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
So then he says they basically committed perjury. Number one, and he says, I need this information. I need to question them, but their answers aren't good enough. I need the documentation because they basically lied before. So if I don't have the documentation, they still shouldn't be able to testify about their relationship with the feds or the defense. You'd say that about every witness.
And they also, another argument that when you really think about it was ridiculous was, if we don't, it will make the trial longer. So the way we shorten the trial is by having another hearing where I get to cross-examine them for another couple of days.
Good point.
You know, so it's 6 of one, half dozen of another. And really, he shouldn't have this opportunity. I really think that, you know, he got to cross-examine them more. You know, defense lawyers don't get these kind of opportunities to have a trial where you've already totally cross-examined the witnesses. So let's have another trial, and I've got that prior transcript, so I know everything they're going to say. He's got a great advantage on the ARCCA witnesses when he goes into this. Now, the discovery issues, you know, we really don't know. We don't know what's out there that hasn't been turned over yet. We don't know if there is anything out there. We know what he says, but we don't know if there is anything out there. But the Rule 14 issue is an important issue for discovery for the judge, and the judge does need to deal with that.
Yeah, and she is, but she's giving them this additional voir dire and additional questioning. So by the time the second trial is over, they will have cross-examined these ARCCA witnesses 4 times in court, which is just wild to think about. All right, a couple other questions before we end. The first is, I don't know if we talked about this in the first trial, but there were no grounds to the objections. And the defense said, hey, judge, can we at least just say hearsay or foundation or something, 1 or 2 words to protect the record so we all know what we're being objected to, less sidebars, quicker trial. She immediately denies it. Yannetti, who is the Massachusetts attorney, says there are other judges in Massachusetts that allow this. What are your thoughts? How much would you hate that in a trial?
I would hate it. I do think they should at least cite the rule number or the grounds for it, like you just said, like hearsay.
Like federal court.
Right. And like I was just going to say, you know, I try a lot of federal cases. The courts don't allow you to argue in front of the jury why it's hearsay, but at least say the word hearsay. So number one, the judge properly rules on your objection, because if you just stand there and say objection, the judge may deny it based on something you're not even thinking about, or based on something the prosecution doesn't even know the mistake that they made, and they could have corrected the mistake if they knew the reason for the objection. They could go back and ask the question the right way. But without even having grounds, they don't even know how to go back and ask it the right way. So it really leaves you in the dark, and it's a kind of a ridiculous way to conduct a trial.
Yeah, I hate it. I hate it more than anything. I think there's millions of issues with it. If I was an appellate court judge, I would give every lawyer every benefit of the doubt if a judge did this. So every possible objection that could apply, I would give it to them. But you're right, because then the person didn't get to respond or change the question, and it just creates such an issue. It's totally unfair, and it's illogical to me. The last question that I had before we get to anything else you want to add is, what do you think about all the lawyer infighting, the digs, the getting up and saying, well, at least you should get one of the facts correct, or getting up and saying, well, he's added the fold of making disparaging comments and lying, basically calling each other liars. What have you thought about that?
Well, number one, I think it's horribly unprofessional, and it's a bad look. Number two, if a lawyer did that to me, I wouldn't sit there. I'd get up and beat him back. I wouldn't sit there and take it. I'd defend myself just like these guys are, And it could end up going back and forth. Let me tell you, no one can sit there and call me a liar in court without me responding to it. Maybe it's not the right thing to do to really come back and attack the other lawyer, but I wouldn't sit there and take it.
Yeah, especially if the judge is not going to control it. Like if
Yeah.
you know the judge is basically doing nothing about it, you don't have a choice. You got to do it, especially during a trial. If it's happening in front of the jury, that's even worse because it looks horrible in front of the jury. You try to compose yourself and you tell the judge, handle this judge and make an instruction to the jury that he was wrong for doing that. And it's not going to happen anymore, basically, is how you have to deal with that.
Plus, you have a
Anything else?
case here. You got a case here that's all over the media and all
Yeah.
over social media. And the fact that this guy's allowed to sit there and call you a liar and you not respond to it, that's just a bad look, a big mistake.
Yeah. Yeah. Completely. Anything else you want to add from the hearing, the last couple hearings? Anything pre-trial? Looking forward to the trial in the case.
I think that I know that in the first trial, there was, and I think a lot of people said there was a lot of bias on the part of the judge. And I think the judge made a bad ruling on the jury verdicts at the very end on the fact that she knew that there were some unanimous verdicts on some of those counts. She should have done that. But she is at least trying in these hearings, it seems, to give them an open forum to let them say what they want to say, present what they want to present. She's not cutting them off. I know that on that one lawyer, I don't know his name, the
Alessi.
guy doing the experts. Oh, yeah, at least
Yeah.
right.
Yeah.
The guy doing the experts. I know she tried to cut him off because she didn't want to hear a repetition because apparently it's his style to give an outline of what he's going to say and then
Yeah.
go ahead and give the detail. But you know what? I think she should have just let him do it the way he wants to do it.
Yeah. Like,
A judge should not control how you present your argument, especially when there's no jury.
right.
So
Well, she
I
did
didn't
say
like.
at one point, she said everybody's going to get 2 minutes, and she did absolutely cut the Commonwealth off at their 2 minutes. And then Yannetti, the defense lawyer, stood up and said, "I can't do this in 2 minutes, Judge." And so they kicked the can down the road, and she didn't end up holding them to that. But she is trying to tighten certain things up. There are a lot of motions flying, and I got to be honest, if I was a judge, I'd be annoyed at lawyers waiting until the deadline to file 50 motions. It's like you had years to file these motions. You should have filed them sooner. So now your time is limited because we only have so much time before trial.
Right. And by doing that 2 minute, again, if she had done the 2 minutes before the oral argument, then she would have given them notice to put everything in writing. But not saying that and then telling them at the oral argument 2 minutes, that really is a real negative to the defense because the defense has a right to present all of their arguments to the judge, and she
Right.
really shouldn't cut them off.
Right. Anything else?
No, this trial is a fascinating trial. It's good lawyers really on both sides, and so I'm enjoying how they're presenting it.
Yeah, I think it's good too. I wish the like name calling and he lied, no, he lied, no, he lied. I wish that would stop. And I do wish the judge would be a little bit more even-handed on the way that she speaks to the lawyers too. It's like she has a disdain for the defense lawyers and doesn't have that same disdain to the Commonwealth. And it's almost like she gets into it sometimes. So I wish that would calm itself a little bit and just be even-handed with everybody. And have I think most of her rulings, she's trying to be even-handed, outside, especially that one was just horrible in my opinion. And there have been some other ones that have been questionable and not as good, but I wish her tone would be more even-handed because that is something I've noticed when the lawyers are arguing, even when it's like she's annoyed that they have to fly in or that, whatever it may be, the annoyances come out and she did a little better in the trial. It didn't come out as much in front of the jury. So that's the really important time.
Well, we're kind of used to that as defense lawyers.
Yeah, exactly.
I mean, we are. Most judges are former prosecutors.
She's actually she's a former public defender, I heard.
Well, then they can be even
That's
more.
what I've heard.
That's what's they called a reformed alcoholic, or even worse.
Yeah, sometimes.
So we're used to that. I really think the Commonwealth. I love saying Commonwealth. Here we call it the state. We had a federal judge in down here that used to say when we were a prosecutor, and at the beginning of the trial, they would say, "Who speaks for the United States?" And it was just wonderful. We'd say to the judge, "I speak for the United States."
Yeah,
That was a great feeling.
Yeah.
But we're used to that as defense lawyers. We're used to
Mhm.
getting beaten on and having to fight hard.
Yeah, yeah, and I think it's gonna be a well fought. I think it's gonna be a very different second trial, so we will definitely stay tuned for that. Thank you, Dad, for sharing your thoughts.
Sure.
Thank you, everybody who's listening. Make sure you guys hit the like button if you're watching on YouTube. Give us a 5-star review wherever you're listening to it on podcast. Subscribe wherever you're at. We're gonna keep it coming. We're going fast and furious. This trial is starting April 1st. There will not be a delay. If an appellate decision comes down, I didn't really ask you about that. So, do you think an appellate decision is going to come down before this trial starts? Let's say April 25th. Let's say they don't start before then.
I thought I heard one of the lawyers argue that they agreed to an expedited calendar and
Briefing, correct.
yes, expedited calendar on this one. So it is possible that it will come down since they did agree to that expedited calendar. And, they're no stranger to know what's going on
Exactly.
in the rest of the city. So they know what's going on in the city. There's a real good chance you'll get a decision by then.
I hope they do. I don't think Karen Reed's going to be successful, but I hope they do wait for an actual decision.
Right. Yeah. I don't think this is
Um,
going to be a federal issue that she's going to be successful on.
yeah, yeah, I tend to agree with that. All right. Well, that's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.